Hi, everybody. This is Gov from CAR, your attorney. I probably know most of you. Anyway, I'm going to talk about the forms that just got released about a week ago. Maybe it's almost 2 weeks now. As you know, CAR does new forms twice a year, end of June, end of December. And it's always a good idea to keep up on what's changed. Remember, 6 months ago in December, we had a really big change, right? We had a new purchase contract. And that was a big deal. Plus, believe it or not, about 95 other forms changed at the same time because they all had to be, consistent with the new purchase contract. And if you have any questions on the new purchase contract, you can ask me. But today we're talking about the June forms release. If you do have questions, please put them in the chat, okay? And I'll be glad to answer them as we go. I think the good news for you is there's not a lot of really crazy new forms, and there's not a lot of really significant changes you're going to have to make to your life. But there are a couple of things worth mentioning that I'm glad you're here to hear, okay? And I'm going to share my screen with just a couple of the forms, not all of them, because a lot of them, it's really pretty basic. So let me start with new forms, right? There's about 7 of them. And then I'm going to talk about the forms that have changed, okay? All right, here we go. Now, first, let's talk about brand new forms. Before I get started at all, this relates to forms. On July 1st, the California eviction moratorium ended. What does that mean? That means, in general, if you want to evict someone, you can evict someone for non-payment of rent. In other words, up until July 1st, you had to apply for rental assistance before you evict someone. And if you were still waiting to hear back from the city or the county to see if you got the rental assistance, you couldn't evict them. Now you can evict someone for non-payment of rent. You don't have to wait to see if you get the rental assistance. But nevertheless, it's still not back to completely normal, because if you're going to evict someone for non-payment of rent, you have to give them a 3-day notice, right? 3-day pay rent or quit. Remember, before the pandemic, there was just one form, 3-day notice to pay rent or quit. Well, now there's still an extra form, and it depends on if you're evicting someone for rent due after April 1st, you use one form. If you're evicting them for non-payment of rent from March of 2020 to September of 2021, you use a different form. I'm not even going to show you these forms. All I'm going to tell you is, if you're a landlord and you want to evict someone for non-payment of rent, or you're a property manager, you might want to call the legal hotline or talk to your own lawyer so you make sure you're using the right 3-day notice form, okay? Then, of course, I'm talking to people in LA County, and LA County has its own rules as far as evicting people for other reasons. Do you know most places in California now, like Orange County, you can evict someone, you don't even need a reason. If the lease is over, they're month to month, you can just evict them. But in Los Angeles County, unfortunately, right now, in order to evict someone, you have the only real, for no fault. In other words, they haven't done anything wrong. You just want to evict them. The only real legitimate way to evict them is if the owner wants to evict them because the owner wants to move in. And of course, we have a form for that too. So anyway, if you're an LA landlord and you want to evict someone, you might want to call your own lawyer, or better yet, call the free CAR legal hotline first, so make sure you have the right form. Okay, all right. Now let's talk about brand new forms. There was one form that came out in January, and I hope you're all aware of it. I call it the mold booklet. It's a form landlords have to give to tenants. Only tenants that were new tenants in 2022. So if you had a tenant last year and there's still a tenant this year, you don't have to worry about it. But all new 2022 tenants, the landlord has to give the tenant this booklet called Introduction to Dampness and Mold for California Renters. Now, if you use the CAR rental agreement, it's already attached to that form. So you're already doing it. But if any of you guys rent to someone this year and you're not using the CAR lease, make sure you email the tenants the form called Introduction to Dampness and Information on Dampness and Mold for California Renters. Where do you get this form? It's on zip forms in the library called Electronic Publications. As I said, for tenants you had last year that are carried over, don't worry about it. If you're using the CAR lease form, don't worry about it because it's already attached. All right. But that's what if you're saying to yourself, oops, I had a new tenant this year and I didn't give it to them yet. Just email it to them now. You don't have to give them a hard copy. You're late, no big deal, no penalty, just do it. All right. Now let's talk about the brand new forms that came out a couple of weeks ago, the June forms. First, we'll talk about the brand new forms. There's only one that's pretty important, okay? And I'm going to share my screen with that one. It's important because it's a mandatory form, okay? And I'll show it to you. There it is, the Fair Appraisal Act Addendum. It's a mandatory form that you got to give to the buyer and seller. But guess what? Really good news. It's pre-attached to the purchase contract. So if you opened escrow after June 21, when the forms came out, this form was pre-attached to your purchase contract. And if you notice on paragraph 8B3 of the purchase contract, there's a checkbox. It's already checked. It says Fair Appraisal Act Addendum. It's already attached. Make sure the buyer and seller sign it. You know what's different about this disclosure? Most disclosures are disclosure from the seller to the buyer. This form, as you can see, it's signed by the buyer and seller. This is a disclosure from the realtor to the buyer and the seller. So don't worry about it. It's pre-attached to your contract. Just make them sign it. But here's one important thing. If any of you opened an escrow before June 21st and you used the CAR form, it didn't have this attached. And if you're, in other words, you opened escrow before June 21st, but you didn't close yet. Well, now you still got to give this form to your clients. So you go to zip form, you look up this form, give it to your clients that are in escrow and have them sign it. What if they won't sign it? That's okay. As long as you prove you can give it, you gave it to them. If they don't sign it, they don't sign it. But you can prove that you sent them the email, that's good. I'm sure they'll sign it. Because all this form does, look at the form. All the form does is it tells your clients that appraisals aren't supposed to be biased, right? Appraisers aren't supposed to be biased based on race, color, all this stuff. And if the buyer or seller thinks the appraisal is biased, they think the appraiser was influenced, they gave you a low appraisal based on who you are, this tells you where to file a complaint. That's all it does. It tells you where to file a complaint. So it is a mandatory form. It's pre-attached to the purchase contract. But if you opened an escrow before June 21st, that means you didn't give them this form. But then if you're still in escrow July 1st, you now have to give them the form. So you just have to send it to them separately, okay? This is the only really important brand new form. And for most of you, it's automatically pre-attached to the contract, okay? That's pretty simple, right? You can do it. Connie, these forms are all on zip forms now, so you can access them easily. You don't need to actually, so I don't think they're gonna be sent to you. There is a handout you can get where it's on zip form. It's called June 20, I'm sorry, it's on your CAR website, called the June 2022 Forms Release Quick Summary. That's also on your website. If you can't find it, any of these stuff, just call the legal hotline and then we'll send it to you, okay? All right, so that's one new form. That's the only really important new form. What are the other brand new forms that just came out? Well, one of them is, if any of you do commercial sales, right? You know, all these years we have this residential seller property questionnaire. Well, guess what? Now we have a commercial seller property questionnaire that has all of the seller, all the disclosures you have to do as a commercial seller. We have them all in one place. So if any of you do commercial, there's no TDS, you know that. There's no lead paint, there's no fire hardening form, but we do have a form now called the Commercial Seller Property Questionnaire, okay? So that's another new form. Third new form, back to commercial. This may never happen to you, but you ever see a listing that's part residential, part commercial? So it's part residential, part commercial. So I want to write an offer on this mixed use property. What form do I use to write the offer? For the last forever, I've been telling you, well, you have to write two offers. You got to write an offer for the residential part of the property on the residential form, residential purchase contract, and you write the commercial offer on the commercial contract. Well, good news, you don't have to do that anymore. We have a brand new form called the Mixed Use Purchase Addendum. So if I'm going to write an offer on a mixed use property, I'm going to write the offer on the residential purchase contract, and then I'm going to attach this brand new form called the Mixed Use Purchase Addendum, and that's going to cover the commercial part. So there's just one form and one addendum to write an offer. I don't know if you do commercial, but just in case, that's what you got it. That's what you use. Okay. Couple more new forms. You know, if you're a broker and you're an agent, whether you're a broker or an agent, you sign this form called the Independent Contractor Agreement, because the relationship between a broker and an agent, you have to have a contract. So we have a form called the ICA, Independent Contractor Agreement. Did you know that up until a couple of weeks ago, we had two versions of this form? One of the independent contractor agreements says if the broker and the agent have a dispute, they have to go to mediation. The other one said if the broker and agent have a dispute, they go to arbitration. Well, guess what? We combine these forms into one form. So now it's sort of like the purchase contract. If the broker and the agent have a dispute, first they have to do mediation. They have to try mediation. But if mediation doesn't work, then they go to arbitration. That's sort of like the purchase contract. So now the independent contractor agreement is, there's just one form, and it's just like the purchase contract. If the two parties have a dispute, they have to mediate. If that doesn't work, then they go to arbitration if they've initialed it. So there's a place to initial the arbitration clause on the independent contractor agreement. By the way, speaking of independent contractors, I need to tell you, you know what the latest lawsuit against agents are? Somebody sues you because they claim that your website, if you have your own website, violates the Americans with Disabilities Act because a visually impaired person can't access it. So think about that for a second. So somebody can't see, they're blind, but they want to see your website. Well, obviously, how do they see your website if they can't see? Well, actually, you can get these sign reading machines. And if the website has this sign reading software, then the visually impaired person, they connect their machine to your website and they get an audio recording of the words on your website. Well, the California Ninth Circuit said real estate websites have to have this software so a visually impaired person can access the words on your website. If you don't have it, someone can sue you. So all I'm telling you is if you're an agent and you have your own website separate from the brokerage website, make sure your website is in compliance. Well, how do I know if my website is in compliance? Well, we have a handout on our website, car.org. You go to risk management, you type in the search, quick guide on website accessibility. It's a one-page doc. If you can't find it, call the hotline and we can send it to you. It tells you what it means to have your website in compliance. Basically, you're going to call your website provider and the website provider will tell you, make sure you're okay. Why am I telling you this now? Because what happens is, what if the agent has a website that's not in compliance? Somebody sues them. Can they sue the broker also? Well, they can, but you know what the independent contractor agreement says? It says that if a broker gets sued because the agent is violating the law, the agent has to indemnify the broker. Okay? By the way, yeah, I'm not showing any forms right now. I'm just telling you about these forms. So, in other words, agents, make sure your website is in compliance, because otherwise you might get sued and your broker might get sued, and then you have to indemnify your broker. You got to pay your broker's legal expenses. So that's worth talking about. Okay? All right. Now, so what have I told you about? We looked at the Fair Appraisal Act addendum. We talked about those two commercial forms if you do commercial. We talked about the independent contractor agreements are combined into one form. And there's two other new forms I want to tell you about. One of them is, okay, did you notice on the purchase contract now, on the new purchase contract, on the last page of the purchase contract? I don't know if you've ever noticed this. I'll pull it up for you. So on the purchase contract, on the last page of the purchase contract, there's a new thing that was not there before. Okay, so now I'm going to pull up the purchase contract. Okay, you see this on the last page of the purchase contract, page 16, where the agents, you're both supposed to put your designated electronic delivery address. You know what the purpose of that is? The purpose of that is let's say I'm the buyer's agent and I put down my email, my designated address, and you're the listing agent and you put your email. We're telling each other, I'm telling you, if you need to send me something, you have to send it right here. Don't send it anywhere else. I have one address. And if I'm going to send you something, you're going to give me your address. But the significance of this is, if we exchange email addresses, that means if I send you an email to the address you gave me, I don't have to prove that you opened it. You know, ever since there's been email, you know what the problem with email is? If I send you an email, you could always say, well, you think you sent it, but I never got it. Or it's in my spam, so I never got it. Or I got it, but I didn't open it. The question is, if I send you an email and you didn't open it, have you really received it? And the answer is no. So all these years I've been telling realtors, when you send something by email to the other agent, you have to follow up and confirm that they got it. Because if you send the email, they can always say, I didn't open it. So for 25 years, I've been telling realtors, send an email, then follow up, make them acknowledge that they received it. Well, you know what? You don't have to do that anymore. Because the way the contract, and they changed the definition of delivery in the definitions part of this contract, right? In the definitions part of the contract, when it talks about delivery, it says delivery means personal receipt. Personal receipt means either a copy of the document has been received or an electronic copy has been sent. What that means is, if I send you something to the address you gave me, as soon as I send it, it's considered to be delivered. I don't have to prove that you opened it. All I have to prove is that I sent it. If I sent it, it's your responsibility to make sure you check your email. Same thing, if you're going to send me an email, you don't have to, as long as you send it to the email address I give you, you don't have to prove that I opened it. So this is a big change. Why am I telling you this? Because there's a brand new form that just came out. It's called the Designated Electronic Delivery Address Amendment. Because what we've seen is sometimes the agents don't, when they're filling out the offer, they don't put the email there, but then they remember, oh, I should have done that. So now there's an amendment form where you can, which is signed by the agents and the buyer and seller, where they can insert the designated electronic delivery address that they forgot to put in when they were writing the offer in the first place. Okay? Not a big deal. One more brand new form. One more brand new form. Have you ever been doing a deal and the other agent gives you a form that you've never seen before? It's not on zip forms. It's not a CAR form. It's not a Downey Association form. It's like a Zillow form or something like that, right? It's a not realtor form. And you're saying to yourself, I've never seen this form before. Am I supposed to be able to figure this form out and explain it to my client? And the answer is no. That is not your job. You're not required to understand the non-CAR form, which is why we have this new form. It's called the Non-Standard Forms Advisory. All this form is, you're giving it to your clients and you're telling them, one of the forms in this transaction that we're signing here is not a CAR form. I am not an expert on this form. I'm advising you to get legal advice on your own to figure out this form. Okay? All right. That is it for the brand new forms. I showed you the Fair Appraisal Act advisory. I told you about this, the commercial seller property questionnaire disclosure form. I told you about the mixed use addendum you can use if you're writing up an offer on mixed use property. We have the two independent contractor agreements combined into one with mandatory mediation and arbitration. We have the designated electronic delivery address amendment. And then we have the form that I just talked about called the non-standard forms advisory. So that's it. That's all the brand new forms. So the next question is, what are the forms that I already used that have changed? By the way, someone asked me a question. Does the seller's agent need to fill out their email address, or can the buyer's agent? That's a good idea. If you're the buyer's agent writing the offer, you don't know, right, which email address the listing agent wants to be their designated address. I know you have their email address, but that might not be the one they want for this purpose. You know what some agents are doing? They're putting their transaction coordinator's address as the designated email address for deliveries, and that's fine, okay? So bottom line, I would let the listing, or maybe you can fill it in for them, but then they might change it. Or maybe it's better just leave it blank and let the listing agent tell you which email address they want, okay? Another question, April, regarding this non-CIR form, is it mandatory? It's not mandatory, but it's just to protect you, right? So if your client is signing a non-CIR form, I mean, your clients expect you to explain the forms to them that they're signing, right? And if it's a CIR form, you probably understand it. But if it's a not CIR form, right? If it's a non-CIR form, you probably haven't explained it to them because it's not a form you're familiar with. So to protect you, I think it's a good idea to give your client this form. It's not mandatory though, okay? All right. Adelpho, just to clarify, when buying mixed-use property, you use a residential purchase contract and you attach to it the mixed-use purchase addendum, right? So, right. In other words, it used to be you had to write up a residential purchase contract and a commercial purchase contract. But now you're just going to use residential purchase contract and mixed use purchase addendum. Okay. Maribel, what if you're this non-standard form? That's a good question. When I was talking about non-standard form, yeah. So let's say Keller Williams or Compass, they got their own form, but you don't work for Keller Williams, you don't work for Compass maybe, so you're not familiar with their form, but they're asking your clients to sign it. It's part of the deal. Yeah, then I think it's a good idea for you to give this form, this non-standard forms advisory, to your client, because you're basically telling them one of the forms you're signing in this contract is not a CIR form, so I'm not an expert on it, so you might want to get advice. They don't have to get advice, you're just protecting yourself. Connie, getting back to this, putting your designated electronic delivery address. What if the listing agent puts their MLS, puts their email address in the MLS? Like I said, it's okay for you to write it into the offer, but they still might change it. Just because that's the email address they have in the MLS might not mean that that's the email address that they want for delivery of documents during escrow. Okay. All right. Now, let's talk about forms that have changed that you sometimes use. Okay. Just a couple, they're not a lot of serious ones. One of them is the cancellation of contract form. This is an interesting form. You're probably going to use it in your life sometimes, right? As you know, when the buyer and seller want to cancel a deal, first you give the other side like a notice to buyer to perform, or a notice to seller to perform, or demand to close escrow. You give them like 2 days, 3 days warning. But if they don't do what they are supposed to do after you give them the warning, now you might want to cancel, right? Now remember, cancellation has two parts. There's the cancellation of the contract, and then there's the deposit. If you're, let's say I'm the seller, I give the buyer notice, they don't remove their contingencies, I give them a notice to perform, they still don't do it, I can cancel. One party cancellation. You don't need the other person's signature. If the buyer's in breach, doesn't do what they said, you can just check cancel. Or if you're the buyer and the seller's not performing, they're supposed to give you some document, they didn't give it to you on time, you give them 2 days warning, you can cancel too. You don't need the other signature. In other words, cancellation is one side can do it. Now, maybe both of you want to cancel. Okay, so you can now say, I'm not just canceling you, I'm proposing we both cancel. What you're really proposing is that they're going to sign this part. Because the problem with cancellation is, yeah, I can cancel without your signature, you can cancel without my signature. But to deal with the deposits and cancellation of escrow, now we need buyer and seller to sign. So, right? So that's how it works. First of all, it's telling you the money isn't released until both sides agree. By the way, what if you're trying to cancel escrow and the other side won't sign? You got to sue them or take them to arbitration. Okay? So ideally, the parties release, the parties agree. There are various possibilities. One possibility is seller authorizes release of the buyer's deposit to the buyer. Another possibility is buyer authorizes release deposit to seller. A third possibility is the buyer gives some of the deposit to seller, but not all of it. Well, now look, there's a fourth possibility. This is new. What if you're canceling escrow, but there's no deposit yet? Well, then you're going to check this box. And everybody agrees, even though there's no deposit, if there have already been some fees agreed to be paid for in the contract, maybe the seller already agreed to pay for something, the buyer had agreed to pay for something. If these costs have already been incurred before you cancel, you still got to pay it, just because there's no deposit. In other words, if the sellers agreed to put in smoke detectors within 7 days, and we're more than 7 days into the deal, the seller still got to pay for it. There's no deposit, doesn't matter. You've agreed to pay for something, you've already made that deadline. Plus, even though there's no deposit in escrow, the escrow company has the right to charge you a cancellation fee. So buyer, you're still going to have to come up with a cancellation fee, even though there's no deposit. The point is, some people think if there's no deposit, there's no contract, and nobody can be forced to pay anything. That's not true. Just because there's no deposit doesn't mean there's no contract. And it doesn't mean if you've already signed a document with the escrow company, you've committed to pay things like cancellation fees. Even though your deposit never made it to escrow, you still agreed to pay stuff, okay? So this is the new part. This number 4 here, there's a new section on cancellation of contract, okay? There's also something new here that you already know is true, but the point is, if the buyer is releasing their deposit to the seller, if we're talking owner-occupied 1 to 4 units, then the buyer never has to release more than 3%. So if the deposit is more than 3%, even though the buyer authorizes release of it, they only are releasing 3% of the purchase price. Anything extra goes back to the buyer. So that's explained a little bit better, okay? All right, so that's the change to that form. Are there any other forms that have changed? Okay, just a couple more. First of all, your listing form has changed, a very slight change. And for some reason, I don't have a copy of it in front of you, but it's not a big deal. Two things I want to mention on the listing contract. Number one, okay, let me go back to the purchase contract. You know how one of the changes to the purchase contract is the fact that what if the buyer or the seller, right, is a corporation or a trust or an LLC, right? So what do you do if the buyer or the seller is a corporation or a trust, or in other words, the client is an entity? Remember on the old purchase contract, you had to sign this addendum called the RCSD, Representative Capacity Signature Disclosure. Well, if you notice on the purchase contract, that's not required anymore. So if the buyer is a trust, corporation, LLC, you simply check this box telling the seller you're an entity, and then you write down the name of the person who's signing on behalf of the trust, corporation, LLC, or estate. In other words, you just put the name of the legally authorized signer. You don't need the RCSD. Well, up until a couple of weeks ago, the listing contract still had this representative capacity signature disclosure. Now, as of 2 weeks ago, the listing contract is just like this. You don't need the representative capacity signature disclosure. It just says who's the legally authorized signer. So now the listing contract is just like the purchase contract. No RCSD required, just legally authorized signer. Okay, so that's good. The other change to the listing contract is, you know how the purchase contract, I'm sorry, I didn't mean to do that. You know how the purchase contract has an attorney fees clause, right? The purchase contract has always had this attorney fees clause that says if the buyer or seller have a dispute, whoever wins, the prevailing buyer or seller, is entitled to attorney fees from the non-prevailing. In other words, if the buyer sues the seller and the seller sues the buyer, the winner, the loser of the lawsuit, has to pay not just their own attorneys, but they have to pay the winner's attorneys. Well, up until 2 weeks ago, the listing contract attorney fees clause said any dispute between the listing agent and the seller over commission, the loser has to pay the winner's attorney fees. But for any other dispute between the listing agent and the seller, everyone pays their own attorney fees, no matter who wins. Well, now, and I'm sorry I don't have it, the attorney fees clause in the listing form says in any lawsuit or arbitration between the listing agent and the seller, each pays their own. In other words, even a dispute over the commission, right? Even in that case, then each one pays their own attorney fees. Why did we do that? It's not because we wanted to do that, because the law changed and we had to do that. Okay? All right. Oh, by the way, Connie asking a question. If you're purchasing a ranch with different parcel numbers, what contract should I use? Basically, you're going to use, that might be a little bit complicated situation. Connie, you might want to email me later and give me more details or call the legal hotline. By the way, I'm going to put in the chat two numbers. First I'll put the legal hotline number that I keep telling you you can call if you have any questions on any of this stuff. And then I'm also going to put my email address. So you can always email me. And I'll give you whatever you want. Okay? All right. Okay. So we got the slight change to the cancellation form. We have the slight change to the listing form. Are there any other forms that are changing that you need to know about? I would say they're just two. They're just two more worth mentioning. Well, there's, okay. You know, in the statewide buyer and seller advisory, they've expanded the paragraph regarding sea level rise. That's only if you sell a house on the coast, right? You're disclosing to your clients there's this issue of sea level rise caused by global warming. It may impact your ability to develop your property. Okay, that's no big deal. All right, so there are two other forms I want to mention. One of them is the request for repairs, right? So you're in escrow, right? You're the buyer. You do an inspection. The inspector finds a problem. You ask the seller, you want them to fix the problem, or you want them to credit you money for the fix the problem, right? And I'm sorry I don't have the form in front to show you, but for a long time now, there's been a place on that form where the buyer checks a box and says, if you do the repairs I'm requesting, I am hereby removing my inspection contingency. Remember, your offer has 8 contingencies: loan, appraisal, inspection, CC&Rs, disclosures, prelim, and reviewing the solar lease, and your offer's contingent on selling your house first. So there are sort of 8 ways to get out of the deal. But on the request for repair form, if you're going to ask the seller to fix something, the seller is usually thinking, well, okay, if I agree to fix this, I need you to remove your inspection contingency right now. I don't want to wait for 17 days, because if I agree to start doing these repairs on the property, I don't want you to come back later and say, oh, I have more things to complain about. In other words, if you want, the seller's saying, if you want me to agree to do these repairs, then you need to remove that inspection contingency right now. So in other words, we've agreed this is all I'm going to do as far as fixing the property. This is it. No more complaints about the property. Okay. But you know what? Some sellers are saying now, some sellers are saying, if you give me a request for repair and you're asking me to fix this stuff, I'll do it, but I'm only going to do it if you remove all of your contingencies. In other words, I want you to remove all of them, not just the loan. I mean, not just the inspection contingency. I want you to remove all 8 of them, or at least some of them, more than just the inspection contingency. So now there's a checkbox on the request for repair form where the buyer is saying, if you do these repairs, I am hereby removing, if you sign this form agreeing to do the repairs, I hereby remove all my contingencies on the attached contingency removal form. Now, you don't have to do this. It's negotiable, obviously. The buyer may say, no, I'm not going to remove all those contingencies. The seller may say, well, I'm not going to do those repairs. When the buyer said, I'm not going to buy your house. I mean, it's all negotiable, obviously. But I'm just saying there's a new checkbox on the request for repair form where the buyer is agreeing to remove all their contingencies if the seller agrees to do the repairs. Or maybe the buyer doesn't check that form, and then the seller can respond to the buyer's request for repair form with the RRRR form, the response and reply to the request for repair. And on that form, there's a place for the seller to say to the buyer, I'm sort of countering your request for repair. You need to sign this, and part of what I'm asking is I want you to remove all of the contingencies that I have designated on this contingency removal form that I'm attaching to the RRRR. Okay? All right. Which leads me to the last form of the day, and then we're going to be done. There's one other form that has changed, and this is the most complicated form you probably deal with. It's called the fire hardening defensible space. Now, I know I'm talking to people in Downey. I don't know if you guys even have in your area any properties that are in a very high or high fire zone. Maybe they are, maybe they aren't. They probably are. But some of you may do deals outside of Downey, right? And there are a lot of places, there are places in LA County and other areas that are in a high or very high fire zone. And if the property's in a high or very high fire zone, you need this form. So first point is, every time you take a listing nowadays, you have to figure out, is my property in a very high fire zone? Is it in a high fire zone? Is it in a moderate fire zone, or is it not in a fire zone at all? How do you know if your listing is in a high or very high fire zone? Well, you look on your natural hazard disclosure report. And if you can't figure it out, ask your NHD rep and say, you just gave me this NHD form. Is this listing of mine in a very high or high fire zone? They know the answer, they can tell you. If you're not in a very high or high zone, if you're just in a moderate zone or a nothing zone, you don't need this form. But if your listing is in a very high fire hazard zone or a high fire hazard zone, you need this form. Okay? Now, this form has two parts. Well, first, it just talks about when is it required. The second part deals with fire hardening, and the third part deals with defensible space. The form has been a little bit reorganized now. Okay, so first of all, the first thing you have to figure out is this law applicable? Well, the fire hardening part is required if the property's 1 to 4, TDS required, and it's in high or very high. The second part, defensible space, same thing. If it's residential 1 to 4, TDS required, it's in a high or very high. Now you notice on the fire hardening part is only required if the house is built before January 1st, 2010. So it's 1 to 4, it's a TDS deal. You know what that means? If it's a probate, REO, bankruptcy sale, or a trust sale, you never need this form, even if you're in a high or very high fire zone, unless it's a trust sale and the trustee used to be the owner. Okay? But assuming my listing is 1 to 4, it's not exempt, it's not a probate, REO, bankruptcy, or trust, and it's in a high or very high fire zone, I need this form. But if it was built after January 1st, 2010, then I don't need to do the fire hardening part, but I do need the defensible space part. If it was built before January 1st, 2010, I need to fill out both parts, fire hardening and defensible space. Okay, So the first thing you do, you figure out if the form is even required. So your NHD person tells you you're in a high or very high. Then you ask yourself, is this a listing on residential 1 to 4? Yes. Is a TDS required? Yes. Okay, now I know I need the form. So we pull up the form. Now the next question is, was it built before 2010 or after? If it was built after, I don't need to fill out paragraph 2. If it was built before, I do need to fill out paragraph 2. You always have to do paragraph 3. Okay, so let's say, what about this paragraph 1C? It tells you how to figure out if you're in a fire hazard zone. I already told you this, right? I said consult with your NHD company or review the report. But by the way, if you want to, you can go to this website and look at the maps yourself to figure out if your listing is in a high or very high. To me, it's easier just to ask the NHD company, right? But if you want to, you can look at it yourself. All right. Let's say I've determined that the form is required and the house was built before 2010. So I got to do this part. Paragraph A is just information to the buyer. Paragraph B is the seller has to answer 6 questions. Do you have certain type of vents? Do you have a wood roof? Do you have landscaping within 5 feet? Do you have single pane? Do you have, the self-explanatory. Remember on the old form, up until 2 weeks ago, there was a yes, but there was no. So you ask the seller, do you have a wood roof? And they say no. You say, great, then don't check the yes box. But then the seller would say, where's the no box? And you would tell your client, well, since it's not yes, you don't check anything. But you know how people are. They say, I want to check no. I want a yes or a no. I don't want a yes or nothing. So isn't that good? There's now a no box. So your sellers will be happy. If they have to fill out this form, they have 6 questions, and the answer is, are you aware? They may not be aware. If it's an absentee seller who lives in Texas, they don't know. So they would just answer no to everything because they don't know. But if it's your house you live in, you're supposed to know what type of roof you have or what type of windows you have. So the answer yes or no. That's one change. So the first change is there's now a no box in addition to just the yes box. Second change, on the old form up until 2 weeks ago, there was a paragraph right here that caused such confusion. You know what it said? It said, the sellers check the box and say, I'm giving you this form even though your property is not in a high or very high fire hazard zone. In other words, this form is required if the property is in a high or very high. But there used to be it was paragraph 2 on the old form, where the seller could check a box, say, I'm giving you this form even though I don't have to. That one always bothered me. I'm glad it's gone because it just caused confusion. Why would you want to give the form to someone if you don't have to give it to them? So now the form is very simple. You give them the form if the law applies. If you have to give it to them, you give it to them. There's no option to give the form to the buyer even though you don't have to. Doesn't that make sense? I think so. All right. So that's the first change. They got rid of that paragraph. So that old 2 is gone. So this used to be paragraph 3. Now it's paragraph 2. The second change is there's now a yes and a no option as opposed to just yes. And the third change is this last paragraph. It used to be paragraph 4. Now it's paragraph 3. It's been sort of rewritten a little bit, but I want to simplify this for you. Okay? All right, so you're the listing agent. The form's required. Your seller has filled out B. Now you're up to number 3. What do I do? Well, the first thing is the property. So California law says if you're going to hire verify, you have to have 100 foot of defensible space. Some cities and counties have their own local vegetation management ordinance requiring defensible space. So the first thing the seller has to figure out is, does my city have a local vegetation management ordinance? I don't know. I don't think Downey does. So they're probably going to put no. If you haven't heard of it, the answer is no. So once you figure that out, now you have to figure out what box to check, right? Now, first thing the seller has to do is tell the buyer what the seller knows. Sometimes the seller doesn't know that the property is in compliance or not. Sometimes they do know. How would they know? Because they actually got an inspection within the last 6 months, in which case they're going to give that to the buyer. Or maybe they got an inspection and they find out they're not in compliance. I would say to you, 99% of your sellers have not done a defensible space inspection in the last 6 months. So you're almost never going to check one of those 2 boxes. You're just going to leave it, seller is unaware. 99.9% of sellers are unaware. So ask your seller, hey seller, in the last 6 months, did you get a defensible space inspection? 99.9% of the time, they're going to say no. If they live in Big Bear, they'll say yes, because in Big Bear, they test every 6 months. But if you're anywhere else in LA County, the seller is going to say no. So you're not going to check these, you're just going to leave it there. Which leads to the next issue, which is who is responsible for making sure the property's in compliance? Meaning, because remember, you're only using this form if the property's in a high or very high fire zone. If you are in a high or very high fire zone, you have to have 100 foot of defensible space. Whose responsibility is that? You see, I have 6 choices. I'm telling you right now, in Downey or in LA County, you're never going to check any of these boxes. Look at number 2 here. There's a local ordinance that requires compliance at point of sale. I will tell you right now, there's nowhere in LA County where there's such a rule. What if are there any local rules that require the buyer to do something special because of a sale? No, you're never going to check that. Is there any local ordinances in LA County that requires seller to do something to obtain any documentation of compliance as a result of the sale prior to close? No. Is there ever a situation, if only state law applies, the seller has obtained documentation? So once again, if for some reason the seller in B2 has obtained documentation, then you're going to check this box and give it to the buyer. Or maybe for some reason the buyer convinces the seller that they're going to obtain compliance. If I were the seller and the buyer said, I want you to go out and get a defensible space inspection so you can give me documentation, I'm probably going to say no. I'm going to say you do it. You know what I'm really saying? I'm saying if you ever have a sale in a very high or high fire zone in LA County, don't check any of these boxes unless the seller is in Big Bear, or for some reason the seller has done a defensible space inspection in the last 6 months, in which case they check this box. Chances are you're not going to check any of these boxes, so it defaults to number 1, which means the buyer is required to obtain documentation of compliance within a year. 99.9% of your deals that are in a very high or high fire zone, this is going to be the thing in LA County. So I'm saying is chances are, I don't know, I don't even know if Downey has an ordinance, but I do know that if it does have an ordinance, the ordinance doesn't require the buyer or the seller to do anything at point of sale. So what I'm saying is, when you get to this paragraph, you as a realtor probably know if you're, wherever your listing is, there's a local ordinance. There probably isn't, so you're probably going to put no. Then under B, 99.9% of the time, the seller's not going to know if they're in compliance with the state law, so you're not going to check anything. And number C, unless the seller has obtained documentation within the last 6 months, chances are they haven't, unless they're in Big Bear. You're not going to check any of these boxes either. So when you get to this paragraph, you're probably going to check not. You're not going to check anything in B, and you're not going to check anything in C. Of course, you may not be using this form very much at all because maybe none of your listings are in a high or very high fire zone. But there are places in LA County that are in these zones. So if you sell outside of Downey, you may run into this. And the way you're going to know, remember, is you're going to ask your NHD provider. All right. It looks like I don't see any more questions. You all have my email. You all have the legal hotline. As you can see, I think this is not a bad forms release. There's not a lot of crazy stuff, right? There's that one new form, the Fair Appraisal Act addendum, which is pre-attached to your contract, so you don't have to worry about it. However, remember the first thing I said an hour ago, if you have a deal that you opened escrow before June 21st, but you haven't closed it yet, then you do need to make sure your clients get this form, right? The Fair Appraisal Act addendum, give it to them now. That's the only new form that's mandatory. I mentioned the 2 commercial forms. I mentioned the 2 independent contractor agreements combined into 1. I mentioned you have an amendment to add the designated electronic delivery address. We have the non-standard forms advisory. As far as the forms that have changed, I pointed out the cancellation form now has a place to check if you're canceling even though there's no deposit. I mentioned all the listing forms. You don't need the representative capacity signature disclosure. And there's no more attorney fees clause in the listing form. So if you have a dispute with your client, each side pays their own attorney. And we mentioned on the request for repair form that now there's a box where the buyer can say, if you agree to these repairs, I'll remove all my contingencies, not just the inspection contingency. And then we talked about this last form, the changes to the fire hardening defensible space form. Basically, the only real changes are there's now a yes and a no box when the seller answers those questions about fire hardening. And there's no place to say, I'm giving you this form even though I don't have to. And let's see, now we have a question from Maribel. So regarding the acceptance on an offer, will the time frame change since delivery definition have changed? That's a good question. Remember, all of your deadlines in the purchase contract start on the day of acceptance, right? That's a very good question, Maribel. So in other words, buyer signs an offer on Monday. Seller signs the acceptance on Tuesday. And then the listing agent sends an email on Tuesday night back to the buyer's agent. Based on what I told you, Tuesday night, as soon as they send the email, whether the buyer opens it or not, as soon as they send it, it is considered delivered. So in the scenario I just gave you, as soon as you send it on Tuesday night, that's the day of acceptance, that's day 0. Whereas on the old form, you might send the acceptance on Tuesday night, but the buyer doesn't open it, the buyer's agent doesn't open it till Wednesday. And Wednesday would be the day of acceptance. But that's no longer the case. The deadline day for the time frames, the day of acceptance is the day it's sent. The acceptance is sent, not the day it's opened. That's a very good question. The last thing I want to mention is just a quick reminder. If you're a landlord or a property manager and you want to give your tenant an eviction notice because they're behind on the rent, call me first, better yet, call the legal hotline so we make sure you're giving them the right form. In LA County, it's still complicated. You got to use the right form before you can evict someone for any reason. Always check with a lawyer like the hotline before you give someone an eviction notice in LA County. Last question people ask me, I'm sorry, Daniel has a question for the ESD, the exempt seller disclosure. Very good question, Daniel. You know, most of your sellers have to fill out a TDS, right? But if it's a probate, REO, bankruptcy sale, or a trust sale, if the trustee didn't used to be on title, you're exempt from the TDS. So you give them the ESD, the exempt seller disclosure. What if the seller has never lived on the property? It's not a probate. It's not an REO. It's not a bankruptcy. It's not a trust. It's just a seller's never lived there. Do they use the TDS or do they use the ESD? Answer, they use the TDS. They're not exempt. But then you're going to say, well, yeah, but they don't know anything about the property. Fine. All of the questions on the TDS, they can put no. Because are you aware? I don't know. So no. But they don't do the ESD. They do the TDS. Okay. Last question. How much can I increase my tenant's rent right now? Okay. All right. If you live in the city of LA, there's a rent freeze. If you're under LA rent control. What if I'm not under LA rent control? Well, if your property is under LA County has its own rules. But what if I'm not under LA City or LA County rent control? Can I increase the rent whatever I want? Well, then you might be under California rent control. If your building is 3 or more units and it was built more than 15 years ago, even if you're not under LA rent control, you're under California rent control, how much can I increase the rent? Answer, you can increase the rent between now and the end of July, you can increase it 8.6%. Starting August 1st, you can increase it 10%. Nicholas Romo knew the answer. But what if right? Actually, it's 8.6 until August, actually, not December. So August 1st, you can go up to 10%. However, what if it's a single family home? So I'm exempt, or an owner occupied duplex. So I'm exempt from LA rent control. I'm exempt from LA County rent control. I'm exempt from all rent control. Single family house. Can I increase the rent as much as I want? Most places, yes, not in LA County. LA County is under a state of emergency. It's still under a state of emergency. Until that state of emergency is ended, you can only increase the rent 10%. So even in a single family house in LA County, 10%. When the state of emergency is over on a single family, you'll be able to increase as much as you want, but not yet. If you're in Orange County, single family, as much as you want, unless you're in a local state of emergency. So my last comment to you is, if you want to increase your tenant's rent, you might want to call a lawyer first to figure out how much I can increase their rent. Okay, because in LA County, it depends on where you are, or if you're not in LA County. All right. Okay, everybody, you all got my contact information. Patricia, lawyer, raise your hand. Maybe if you unmute yourself, I can hear you, but I don't know if that's even available on this webinar. Try it. Otherwise, send me an email, okay? Okay, guys.